we're not actually taxing property without apportionment, and that all makes sense. Okay, so, you know, revenue taxable activities. Just another example of a revenue taxable activity. Gambling in the Internal Revenue Code is a revenue taxable activity, and they tax that. They don't, or they, like I said, the distillation of alcoholic spirits. That activity is a revenue taxable activity, and they tax it. All right, so get back to the income tax. Now, we all think because we go out and labor, and we labor for 40 hours, and we get X amount of money for that, that somehow that money that we get, and some of my friends will cringe at me calling that money. They'd rather I called that currency, because real money is gold and silver. But nevertheless, we got to use the term here. So that money that they get, they think it's income, and they think it applies to the income tax, so-called income tax laws, and they have to pay some money to the federal government on that basis. Okay, but then let's jump back in here with, okay, is this so-called income tax a direct tax, or is it an indirect tax? And well, we don't have any apportionment going on. 16th Amendment didn't change the Constitution. It didn't allow for, like some people think, a direct tax without apportionment. It never allowed for that. That's not what the Supreme Court said. It said that this is happening because it's taxing an activity, and an activity is an indirect tax, and that's fine. Keep going along with that. Well, then you'd ask, okay, then what is the activity that I'm engaged in that's a revenue taxable activity? Well, you can see in the Internal Revenue Code lots of taxes, lots of impositions of taxes in the code. Well, and you'll find that every last one of them is a tax on an activity. So they're all indirect taxes. There's no direct taxes happening from the federal government right now. Haven't been for maybe centuries if we look back. I can't tell you when they did have a direct tax. So if it's an activity that's being taxed, what activity? Now, like I said, those other activities I mentioned, they're in the code, you can tell. But what does the Internal Revenue Code do instead there when it comes to this so-called income tax? They say that it's a tax is hereby imposed on the taxable income. Now, can you tell with that kind of statement, or if they're talking about a direct or an indirect tax? No, you can't. And then that brings or begs the question, if you were to write to the IRS and say, IRS, is this a direct tax, a so-called income tax, or an indirect tax? Well, I don't think you're going to get an answer. I know I never have. All right, so if you do that and you don't get an answer, so where do you go from there? Well, you go, what am I engaged in? What kind of revenue taxable activity am I engaged in here? Can't think of one, right? You're just laboring for your survival, and that's not written in the code. Well, let's go a little bit further. So I'm questioning, we get to the point where I'm questioning the IRS, and I say, you know what, and you go a little further than that too. When you get into Supreme Court cases, they talk about income as being the gain from capital, from labor, or from the two combined, and they speak of a gain. Now, if you put your labor out and it's got a certain value, and then this is not an argument we'd make with the IRS either, because then this is very confusing. People have done this, gone over this material over and over. They would do that. I wouldn't argue and say, well, I might say I didn't have any income, all right, and then let them prove that I did. But I wouldn't say I didn't have any income because what I got for my wages was an equal exchange. But in essence, it is, isn't it? It's not a gain, all right? And again, if you're going to try to get through the tyrants that believe that they're entitled to the fruits of your labor, you're making that argument is not going to work. It's better to make them show where in the code the tax has been imposed on you, and to prove that you had income. But you go a little bit further there and you say, try to get the IRS to answer these questions. It doesn't happen. And then in my own personal case, so at that point when I understood this, and I understood that signing one of their forms under the penalty of perjury when I didn't believe it to be true, I would be committing perjury, and that would be a crime, so I could no longer sign one of their forms. Well, and it wasn't, with all these complicated theories that I'm not doing it because this, that, or the other thing. I'm just doing it because simply I wasn't engaged in any activity that in the Internal Revenue Code imposed a tax on me, and I certainly did not have income as the constitutional definition of that term is. So it just didn't apply to me. And then you get into the code and all the rules and regulations, they apply to someone who's a taxpayer. Taxpayer is defined in the code as someone who is subject to or liable for an Internal Revenue Code tax. Okay, so now here we are, we're cruising around in the early 90s, and I'm figuring this stuff out. I actually did file tax returns up until 93, and then come 94, I'm not doing it because, up until that period of time, I'm studying all this stuff, trying to figure it out, trying to make sure I do the right thing. Well, and then we come into, say, around 1997, and the IRS is sending me things where they're saying, notice a proposed assessment. And I write back to them and I say, I'm not a taxpayer, not subject or liable for any tax. Please show me in the code where I've been made subject or liable for the tax. And they wouldn't do it. They just were non-responsive. Then we got a little bit further. In 1998, they send out what they called, "We have changed your account" form. Now, instead of saying we have assessed taxes, they said we have changed your account. That's all. I don't even have an account. What are you talking about? And later on, they'll find that there's some documents that say they assessed taxes at that point in time or on that date, which they won't produce any assessments for you. And try to get them through Freedom of Information Act, you name it, whatnot. So through that period of time, starting with 98, correspondence going back and forth and saying, show me the assessment, show me what code section imposed the tax, with some other just common sense questions, and they would never answer those questions. Now, they would, in their little process to try to get money out of me, they would send notices of levy and notice of levy to the banks and to my company. Well, these notices of levy, and this is a disputed debt, keep that in mind, and the Constitution under the 7th Amendment gives us a right of, or guarantees us a right of trial in any dispute of $20 or more, and I've disputed this all along. Well, I find out during that period of time that it's typical for the IRS to send out these notices of levies to banks, notices of levies to your employer, all without court order, and certainly with, in my mind, violating your right under the 7th Amendment to have a trial by a jury on any dispute of $20 or more. And so they'll try to suck your bank accounts dry, get your employers to turn it over, and of course, in most cases, they always do. It's just like it's the government, and obviously they wouldn't do anything that was illegal. And our founding fathers tried to set up a system that would protect us from all of that. Well, guess it didn't, and the reason it didn't because we weren't eternally vigilant. Okay, and then later on down in the process, they do this notices of levies for years, and here's, coming into 2000 and something, or maybe the first time was around 1999, they summons me to go to their office, and their summons is, a Internal Revenue summons. Now I'm studying the codes and everything, and I find out, look, I don't have to go into their offices. What jurisdiction would they have over me? It's not court ordered, and I read the code sections in regard to this, and this is what I interpreted. And then lo and behold, a few years later, there's a court case exactly on that basically says we don't have to go into the IRS offices unless ordered by a court to do so. That's a good piece of information. So anyway, I don't go, and then several years pass, and then another aggressive IRS agent decides to open up this can of worms again and sends a summons to me again to go into their offices. I respond in a like manner, and then they file a petition with the United States District Court to compel me to go. That's a nice little process too, and I denied the court having any jurisdiction because simply there was no law or code section in Title 26 that imposed any obligation on me, and they have to have subject matter jurisdiction to actually have a case, and that subject matter jurisdiction can't be manufactured out of the air. It's got to be made pursuant to some code, some statute within Title 26. And I argued, of course, it would be no different than under Title 27 they had to do with Indians if they tried to apply something in that title to me, and I'm not an Indian. And so, but when the big important lesson I got out of this court case, and I ended up taking it through the appellate process, was that they don't care about the federal rules of civil procedure, their own rules, because I filed a motion for the for the court to dismiss the case based on the lack of jurisdiction, and even if I was all wet, what the court is supposed to do is to hear that motion, and then if they're going to deny it, they deny it. Then they give you 10 days to answer the government's petition. What happened in this particular tyrannical court is they tried to combine, or they in essence combined the two things on the same day, not allowing for any 10-day notice or 10-day time frame to respond in writing if your motion for dismissal was dismissed. Any lawyer with a basic law 101 would understand that that's a violation of due process and should be grounds for a judge to be recused. You can give us the shaft, but give us the due process. And that didn't occur there. The judge said something like, well, if I decide to deny your motion for dismissal, and I actually never consented to the jurisdiction of the court, then and then I order you to attend the IRS summons. I expect you to do that. And I said, what? You're not going to give the 10-day period required by the Federal Rules of Civil Procedure? And she said, well, what else would you say? And then I said, excuse me? Because, what else would you say? That's a big burden to put on somebody to say verbally what he's going to say there when he has a right to brief his arguments. And so, lo and behold, the judge came back and went ahead and denied my motion for dismissal and granted their petition. Of course, then I filed motions for reconsideration, motions to have the judge recused. And sometime in the intervening thing there, then the judge realized that she had to give me my opportunity to brief my points and have my little day in court, if you will, for opposing the government's petition. Well, guess what? And I had good arguments too, and some of those arguments actually relate to if you're carrying books and records that the IRS orders you to carry into their regarding taxes, regarding tax years, so-called tax records, and you say that you're not a taxpayer and you don't owe any taxes, and they require you to bring in records that reflect taxable income, etc., etc., they're compelling you to testify against yourself just by mere presence of bringing in records. Well, I ended up going into their session and they asked me what I had in my box, and I said papers. I never said the records that they supposedly wanted, and I went through the appellate process. Of course, I got nowhere with that. They never had to show jurisdiction. They don't have to show the tax laws, and they can tax because of some of these bogus arguments. They can include me in as somebody making frivolous arguments. If I say I'm not a taxpayer, I'm not liable for any tax, there's no code section, then they'll turn around and say, yeah, Joe Jones over here said that he's a sovereign citizen, so therefore he doesn't have to pay taxes, or Joe Jackson says that he's a U.S. citizen, or he's not a U.S. citizen, he's a citizen of the state of California.